This is the brief on Philippine intellectual property infringement. The Philippine Intellectual Property Code lays down exactly how the state protects creators and heavily punishes anyone who steals patents, trademarks, or copyrights. I mean, think about it. What would you do if someone just completely ripped off your hard work? First, let's look at the crime itself. Infringement happens when someone makes, uses, sells, or imports protected works without permission, especially if it tricks buyers. It's really just plain theft. It's literally the equivalent of someone moving into a house you built, right, and just slapping their name on the mailbox. Second, we've got the civil remedies, which is how the court stops the bleeding. Victims can get immediate injunctions to halt the activity and actually recover lost profits, which can even be doubled if the thief acted with intent to defraud. And get this, they don't just tell you to stop, they literally smash the counterfeit molds and wrappers without compensation, so you can't just hit print again tomorrow. Finally, there are the criminal penalties. For copyright infringement, a first offense means 1 to 3 years in prison, but if you're caught a third time, that'll land you 6 to 9 years behind bars, plus a massive fine of up to 1.5 million pesos. It's a crazy steep scale designed to utterly bankrupt serial counterfeiters, proving this is definitely far more than a mere slap on the wrist. So whether it's through smashed machines, double damages, or nearly a decade in prison, the Philippine IP Code ensures that stealing someone's brilliant idea comes with a devastatingly high price tag.
Welcome to Engineering Protection, a strategic blueprint to enforcement, infringement, and remedies under Philippine Intellectual Property Law, Republic Act No. 8293. The intellectual property system is vital to the development of domestic and creative activity. Understanding the anatomy of an intellectual asset begins with its protection. Copyright protects original expression, a trademark protects the commercial identifier, and a patent protects the technical solution and functional invention. The triad of protection defines the boundaries under RA 8293. Patents cover inventions and designs. Trademarks cover visible signs distinguishing goods. Copyrights protect original works. Each has specific infringement definitions and terms of enforceability. The filter of exceptions defines authorized uses versus commercial infringement. Exceptions include good faith prior users, fair use for purposes like criticism or research, and private and non-commercial acts. Unauthorized commercial exploitation triggers full legal remedies. Liability extends beyond the direct manufacturer through contributory infringement. This chain of contagion includes the direct infringer, the active inducer, and the component supplier. The law treats these network actors as equally liable through joint and several liability. The path to justice involves 3 steps. Step 1. Establish knowledge using statutory mechanisms like the registered mark symbol. Step 2. Secure evidence, utilizing court orders for immediate seizure. Step 3. Judicial enforcement through filing a civil action to secure an injunction and demand restitution. The scale of restitution provides for civil damages to make the right holder whole. The baseline calculation is actual damages plus infringer's profits. Malicious intent triggers the multiplier effect, allowing courts to double damages for trademarks or award up to 3 times for patents. Market cleansing is the physical eradication of infringing materials. This includes the seizure of the roots, all implements used to manufacture the goods. These items are subject to destruction without compensation. The simple removal of a fake logo is insufficient, as the physical product is tainted. The escalation staircase outlines criminal penalties. For copyright infringement, penalties increase with repeat offenses, ranging from 1 to 9 years imprisonment and compounding fines. Trademarks and patents also carry foundational criminal penalties. Jurisdiction Without Borders empowers foreign right holders from treaty-aligned countries to bring action. They may wield Philippine IP Code regardless of whether they are licensed to do business locally. The fortress protects the asset, regardless of the architect's origin. The ironclad defense summarizes the systemic framework of Philippine IP enforcement. Prong 1. Economic restitution involves stripping profits and multiplying damages. Prong 2. Market cleansing eradicates the physical infrastructure of theft. Prong 3. Punitive deterrence involves criminal fines and imprisonment, making IP theft unprofitable. The blueprint for the right holder transforms statutory rights into business security. Step 1. Secure the shield by registering patents and trademarks early. Step 2. Establish the boundary by monitoring and affixing proper notices to products. Step 3. Deploy the sword by enforcing rights through immediate injunctions and seizure.
You know, If you've ever poured your heart into creating something, maybe a song, a cool design, or even a new invention, you've probably had that sinking feeling, that nightmare of someone just taking it. Well, today we're going to flip that script. We're turning that fear into a solid game plan. We'll break down exactly what the law in the Philippines says happens when someone crosses that line and infringes on your intellectual property. So you'll have the power to protect what's yours.
It's just a gut punch, isn't it? You see your work, your brand, your idea out there being used by someone else, and they didn't even ask? It feels so personal, and it is. But the response? That's got to be legal. So, what do you do first? What power does the law actually put in your hands? That's the big question we're tackling right now. Okay, so before we jump into the penalties, and trust me, they get serious, we need to be super clear on what it means to actually cross the line. The legal term for it is infringement. But what does that really mean? Well, it's a little different depending on what kind of IP we're talking about. Nailing these distinctions down is honestly the first step to knowing how to fight back effectively.
All right, let's start with copyright. This is for all the creative stuff, your art, your music, your writing. When you create something, the law gives you this whole bundle of exclusive rights. Think of it like this. If someone else reproduces, distributes, or even just displays your work publicly without getting your okay, that's infringement. Simple as that. The law basically hands you the keys and puts you in the driver's seat for your own creation.
Next up, patents. Now this is all about protecting inventions. And honestly, infringement here is pretty straightforward. Let's say you patented a brand new gadget. If anyone, and I mean anyone, makes, uses, sells, or even just imports that gadget without your permission, they are infringing on your patent. And that goes for products made using a special process you've patented too. And rounding it out, we have trademarks. We're talking about the logos and brand names we see every single day. For trademarks, the absolute key idea is confusion. It all boils down to this. If someone uses a logo or a name that's so similar to your registered trademark that it's likely to confuse customers, making them think their product is actually your product, well, that is textbook trademark infringement.
All right, so the worst has happened. Someone's infringing on your rights. What now? Your number one priority is to stop the bleeding, right? Stop the damage immediately. And the law gives you some seriously powerful tools to do exactly that. We call them civil remedies. And you can really think of this as your legal first aid kit.
So what's in that first aid kit? Well, your immediate response is this powerful legal 1-2 punch. Step 1, you hit them with an injunction. That stops them dead in their tracks. And step 2, you get the court to impound all the infringing stuff and, crucially, all the evidence that goes with it. Let's break down what that really means.
First up, the injunction. This is basically a giant, legally binding stop sign. It's an official court order that says you have to stop all infringing activity right now. And this isn't just a suggestion, it's got real power. The court can even use it to block infringing goods at customs, stopping them before they even hit the streets here.
So when we say the court can impound things, what are we talking about? Oh, it's way more than just the fake products themselves. The court can order the seizure of their entire operation. We're talking the infringing items, sure, but also their packaging, sales invoices that show exactly how much money they've made, and even the tools they use to make the fakes, like the plates, mords, the whole shebang. It completely freezes their operation and locks down all that critical evidence.
Okay, so stopping them is crucial. That's step 1. But what about the financial hit, the money you lost because of this? And what about the profits they made off of your hard work? Well, the next step is all about making it right. It's time to make the infringer pay up.
So how does a court figure out how much you're owed? Generally, it's one of two ways. It's either the profits you lost, what you would have made if this never happened, or it's the profits the infringer actually gained from using your work. And here's where the law gives you a huge leg up. All you have to do is prove what their total sales were. The burden then flips to them to prove all their expenses and costs to try and lower that number. And trust me, that's a much harder job.
And this is where the law really starts to show its teeth. Because it's not just about getting your money back, it's also about punishment. Get this. For patent infringement, a court can order the infringer to pay up to triple the actual damages. For trademarks, if you can prove they were deliberately trying to fool people, those damages can be doubled. The message here couldn't be clearer. If you do this on purpose, it's going to cost you. Big time. So everything we've talked about so far has been on the civil side of things. Stopping the activity, getting paid back. But we're about to raise the stakes. Because in some cases, infringement isn't just a business dispute, it's a straight-up crime.
And this is where we move from just fines to actual jail time.
I mean, just take a look at the criminal penalties for copyright infringement. This is serious stuff, and it escalates fast. For a first offense, you're already looking at 1 to 3 years in prison and a pretty big fine. A second time, it jumps to 3 to 6 years and up to $500,000 pesos. And for a third offense, we are talking 6 to 9 years behind bars and a fine of up to 1.5 million. The law has absolutely no patience for repeat offenders.
And it's not just copyright either. If you repeatedly infringe on a patent, you could be looking at up to 3 years in prison. Trademark infringement? That can get you up to 5 years. The message is just crystal clear across the board. Stealing intellectual property is a serious crime, and it comes with potentially life-altering consequences.
Okay, I know what you might be thinking. All these penalties sound great, but how on earth do I prove my case in court? It sounds so complicated. Well, I've got some really good news for you. The law itself actually gives creators like you some pretty powerful legal shortcuts right from the get-go.
Yeah, the law is actually designed to make your life easier here. Check this out. If your name is on your work, the court automatically presumes you're the author. Simple. A notarized affidavit, that's accepted as solid proof of your ownership right off the bat. And here's a big one. If the defendant doesn't even bother to challenge your copyright, the court just assumes it exists and that it's yours. These legal presumptions are huge. They really help speed things up and put the pressure back on the person who did the infringing.
And you know, all of this, every penalty, every remedy, it all comes back to a fundamental principle. It's written right there in the law itself. The reason all these protections exist is because the state has made it an official policy to protect the exclusive rights of scientists, inventors, artists, basically all gifted citizens. It's a recognition that protecting creativity isn't just nice, it's absolutely vital. So here's the bottom line. The law gives you both a shield to defend your work and a sword to fight back with. The protections are strong, the penalties are severe. Really, the only question left is, are you prepared to use them?
Imagine spending like 10 years and $100 million inventing a life-saving medication. You're poring over microscopic data in a lab while your competitors are asleep.
Sounds exhausting, honestly.
Right, it is. And then the day you finally release it, a rival company just legally copies your exact chemical formula. They manufacture it overnight at a fraction of the cost, and they put you completely out of business.
Which is a terrifying scenario for any business.
Yeah, exactly. And without one specific, highly constructed legal concept that wouldn't just be a possibility, it would be standard business practice. So today we are opening up the invisible vault that protects human ingenuity.
We are indeed.
We are doing a deep dive into Republic Act number 8293, which is widely known as the Intellectual Property Code of the Philippines. And the goal here, for you listening at home or on your commute, is to translate what is essentially a massive, incredibly dense legal architecture into a map of how the modern world actually functions.
Because, this isn't just about dusty courtrooms and guys in suits.
No, not at all. If you are listening to this, this is about the smartphone in your hand right now. It's about the logo on your coffee cup, the movies you stream, and, like we said, the medications you trust. It dictates exactly what happens when the invisible boundaries of human creativity are crossed.
Yeah, and the challenge at the heart of this entire legal framework is, how do you draw a boundary line around a thought?
That's the million-dollar question.
Exactly. With physical property, it's binary. You build a fence. The land is yours. Or it's your neighbor's.
Yeah.
Pretty simple. But intellectual property requires a government to put a padlock on something completely intangible. And doing that requires a profound philosophical compromise between the individual and the public.
Okay, let's unpack this, because before we get into the nuts and bolts of what actually gets a padlock, we have to look at the motivation. Why does a society even bother writing hundreds of pages of legislation just to protect an idea? Because intuitively, sharing ideas seems like a good thing for humanity.
It does. And to understand the motivation, we have to look at the state policy established right at the beginning of the code. Section 2. The law is attempting a very, very precarious high-wire act here.
How so?
Well, on one side, the state recognizes that protecting the exclusive rights of scientists, inventors, artists, and other gifted citizens is absolutely vital for economic survival.
Like the medication example.
Exactly. If an inventor knows that the second they reveal a new microchip, 10 giant factories will instantly copy it and undercut their price, that inventor will simply stop inventing. The capital investment required for research and development It just evaporates without a guaranteed period of exclusivity.
The incentive structure completely collapses. I mean, if anyone can harvest the crop, no one is going to bother planting the seeds.
That is a perfect way to frame it. However, the counterbalance is just as important. The law explicitly states that the use of intellectual property bears a social function.
A social function? What does that mean in practice?
It means the ultimate objective of the government is not just to make individual geniuses incredibly wealthy. The goal is the diffusion of knowledge for national development. So the state offers a grand bargain.
I love a grand bargain. What are the terms?
The government will grant you a temporary, incredibly powerful monopoly to exploit your creation. But only on the condition that your creation is fully disclosed, and eventually that monopoly ends. So society as a whole benefits from the knowledge you put out there.
A grand bargain between the genius of the individual and the progress of the public. That framing makes so much sense. But a bargain of that scale requires a rather sophisticated referee, right?
It definitely does.
And that brings us to the Intellectual Property Office, or the IPO. Reading through the source material, the structure of this agency really struck me. It operates almost like a registry of deeds, but for the invisible architecture of the human mind.
Yeah, that analogy holds up incredibly well when you examine how the IPO is physically and structurally divided under the Act. It's headed by a Director General, sure, but underneath that leadership, the Act creates 6 distinct bureaus, and they each function almost entirely independently.
Wow, 6. Let's go through them.
Sure. You have the Bureau of Patents, the Bureau of Trademarks, the Bureau of Legal Affairs, alongside bureaus dedicated to documentation and technology transfer, management information services, and administrative services.
Which naturally raises the question, for me at least, of why an idea needs so many different administrative silos. If it's all just intellectual property, why not just have one massive team of examiners evaluating everything that comes through the door?
Well, the administrative reality there is that intellectual property is not a monolith at all. I mean, the skills required to evaluate a new mechanical turbine are entirely distinct from the skills required to evaluate a brand logo.
Oh yeah, that makes sense.
Well, right. A patent examiner in the Bureau of Patents is engaging in highly specialized scientific scrutiny. They are analyzing chemical structures, software algorithms, just to ensure they actually work.
They're scientists and engineers.
Exactly. Meanwhile, a trademark examiner is operating in the realm of psychology, commercial branding, and consumer behavior. They're analyzing whether a new logo creates an acoustic or visual resonance that might, confuse a buyer in a supermarket.
So they're speaking entirely different languages. One is the language of physics, and the other is the language of marketing. And then you have the Bureau of Legal Affairs, which seems to act almost like a specialized tribunal.
That's an essential component. The Bureau of Legal Affairs handles complex cancellations, oppositions, and compulsory licensing disputes.
Instead of just going to a normal judge.
Right, because IP law is so incredibly specialized, you don't necessarily want every single dispute clogging up the regular civil court system immediately. You need a body of experts who actually understand the nuances of a patent claim to handle that initial friction.
Now, there was a specific structural detail regarding how the IPO is funded that I found fascinating. Section 14, I think? The law authorizes the IPO to retain its fees, fines, royalties, and other charges.
Yes, that's a very unique setup.
Right, because unlike a standard government agency that has to remit every single peso back to the national treasury and then essentially beg for an annual budget, the IPO gets to keep its own revenue to upgrade its facilities, acquire office space, and train its personnel. It almost sounds like the law designed the IPO to function with the agility of a private tech startup rather than a slow-moving bureaucracy. Does that make it function more like a private business than a standard government agency?
Building on that startup analogy, it's really a matter of sheer operational survival. The law explicitly states this financial independence is for the more effective and expeditious implementation of the Act.
They have to be fast.
Exactly. Think about the sheer volume of data they process. Patent examination requires access to massive, constantly updating international databases. It requires modern, high-speed server architecture and the ability to hire highly competitive technical experts.
Who probably command high salaries in the private sector.
Exactly. If the IPO had to wait for congressional approval every time they needed to upgrade their software, the entire innovation pipeline of the country would just grind to a halt. A modern economy requires an intellectual property office that moves at the speed of modern invention.
The referee has to be as fast as the players.
Precisely.
And speaking of the people running the system, the rules surrounding the employees of the IPO are incredibly strict. Section 19 paints a picture of absolute, almost paranoid integrity.
Paranoid is a good word for it.
Right. Officers and employees of the IPO are completely disqualified from applying for a patent, a utility model, an industrial design, or a trademark during their employment.
And not just during their employment, but for 1 full year after they leave the office. They are also barred from acting as an attorney or agent for any applicant during that time.
So it's a mandated cooling off period. The only exception I saw in the text was if an employee acquires an IP right through hereditary succession. Like if their parent passes away and leaves them a patent in a will, but otherwise they are entirely locked out of the system they administer.
They are.
It really shows how terrified the drafters of the law were of the concept of insider trading in the world of ideas.
Well, they had to be. The entire system relies on the absolute trust of the applicants. These examiners are looking at the world's most valuable corporate secrets years before they ever hit the public market.
Oh, wow. Yeah, that's true.
If a pharmaceutical company suspects that an IPO examiner might see their new drug formula, reject the application on a technicality, quit their job, and then file a similar patent themselves, the trust just evaporates.
And the grand bargain collapses.
Right. The strict disqualification is the only way to guarantee that the vault is secure.
Okay, so we have the administrative foundation laid out. We have the specialized bureaus, the agile funding, and the strict rules of integrity. Let's walk through the doors of the very first major bureau mentioned, the Bureau of Patents. Because the law makes it abundantly clear that not every good idea is a patentable invention.
The threshold for a patent is arguably the highest in all of intellectual property law. Under Section 21, a patentable invention must be a technical solution of a problem in any field of human activity.
A technical solution.
Yes, but it's not enough to just solve a problem. The solution must meet 3 absolute unyielding criteria. First, it must be new. Second, it must involve an inventive step. And third, it must be industrially applicable.
Okay, let's test these criteria. Because new feels somewhat intuitive, but the legal definition is incredibly rigid. The code states an invention is not new if it forms part of prior art.
Prior art, yeah.
Which basically means if the solution has been made available to the public anywhere in the world in any format before your filing date, you're out of luck.
And anywhere in the world is the critical phrase there. If you invent a new type of water filter in your garage in Manila, but a researcher in a tiny village in Norway published a paper describing the exact same mechanism 10 years ago, your invention is not new.
Even if I never read the paper.
Even if you never read it. Even if you genuinely came up with it completely independently. The public already has access to that knowledge. Therefore, the government has no reason to grant you a monopoly on it. The knowledge is already out there.
Man, that makes the prior art search incredibly daunting. You're competing with the entire history of human publication.
You really are.
But let's look at the second hurdle, which I suspect is where most dreams die, the inventive step. What exactly elevates a new idea into an inventive one?
Section 26 defines an inventive step by looking at the invention through the eyes of a hypothetical person, a person skilled in the art.
Who is this person?
They're an imaginary expert in that specific field. If this hypothetical expert looks at all the prior art, all the existing knowledge, and finds your new invention to be obvious, then it lacks an inventive step.
So it can't just be the logical, routine next step that any competent engineer would eventually figure out anyway.
Exactly the opposite of routine. It requires a genuine leap of human ingenuity. Let's say you have a known chemical compound that cures headaches, and you simply decide to manufacture it in a liquid gel cap instead of hard tablet so it dissolves faster.
That sounds useful.
It is useful, and it's new. But a person skilled in pharmaceutical manufacturing would likely consider that an obvious modification. It doesn't take a spark of genius to put liquid in a capsule. Therefore, no inventive step, no patent.
Got it. And the final criterion, industrially applicable, that seems to ground the whole thing in reality. It just means the invention can actually be produced and used in an industry.
Yes. You can't patent a purely theoretical concept that only works on paper, but defies the laws of physics when you try to actually build it. It separates science fiction from engineering.
Which makes sense.
The Patent Office isn't there to reward imaginative storytelling. It's there to protect functional tools that drive the economy.
Which brings us to Section 22, the list of non-patentable inventions. This is where the law explicitly draws a boundary around what humans are actually allowed to monopolize. For instance, you cannot patent a mere discovery, a scientific theory, or a mathematical method.
And you have to consider the alternative to understand why. If someone could patent the formula for calculating the circumference of a circle, or a newly discovered law of thermodynamics,
Fate own reality.
they could charge a royalty every time a high school student did their math homework, or every time an aerospace company launched a satellite. The law views discoveries and mathematical methods as universal truths. They are pre-existing facts waiting to be found, not human creations. You can't put a padlock on the universe.
I love that. You can't put a padlock on the universe. Now, the law also excludes rules for playing games, methods for doing business, plant varieties, animal breeds, and aesthetic creations. So, if I sit down and spend a year meticulously crafting a totally original, highly complex new set of rules for a board game, maybe a strategy game that perfectly simulates the global economy, I cannot patent those rules.
No, you cannot. The rules of a game dictate human behavior in an abstract system. They do not provide a technical solution to a physical problem.
Okay, but what if the game itself is physical?
Well, that's the distinction. If your board game involves a revolutionary new physical mechanism, say a board that uses magnetic levitation to track player movement in a way that has never been engineered before, that specific magnetic mechanism might be patentable, even if the rules of the game are not.
Ah, so it's all about the physical, technical mechanism.
Exactly.
Okay, so let's say I actually do it. I invent a genuinely new, industrially applicable mechanism with a massive inventive leap. Let's go with a classic sci-fi trope. I invent a crude but functional teleportation device in my garage.
Congratulations.
Thank you, I'm thrilled. But I want to spend 6 months perfecting the cooling system before I show the world. Meanwhile, across town, another inventor independently builds a slightly clunkier teleportation device tomorrow and immediately runs to the IPO to file his paperwork. According to the first-to-file rule in the code, he owns it.
Under the strict administrative reality of Section 29, yes. If two or more persons have made the invention separately and independently, the right to the patent belongs to the person who filed an application first.
Wait. That feels fundamentally unjust. If the law's stated policy is to reward genius and protect the actual creator, how can it reward a slower inventor just because they have a faster lawyer or decided to rush to the post office? It feels like we are punishing the more meticulous scientist.
That is the friction point that has driven debates in intellectual property law for decades. It really does feel counterintuitive to fairness.
It really does.
But you have to view it from the perspective of the government's primary goal, the diffusion of knowledge. The state wants incredible inventions disclosed to the public as rapidly as possible. If the law rewarded the first to invent, an inventor could sit on a world-changing technology for 20 years in secret.
And just hoard it.
Exactly. And if someone else ever tried to patent it later, the original inventor could just pop up, show their old dusty lab notebooks, and claim ownership.
Oh, I see. So it would create endless, unresolvable litigation over who thought of it first in their basement.
Precisely. The first-to-file system replaces murky historical investigations with an objective, stamped date on a piece of paper. It heavily incentivizes a race to the patent office, which means the public gets to see the technology sooner. Administrative efficiency, in this case, trumps absolute cosmic fairness.
Okay, I understand the brutal logic of independent invention, but what if it wasn't independent? What if the guy who filed first actually broke into my garage, stole my blueprints, and submitted them as his own? Does the first-to-file rule still protect him just because he got to the clerk's desk before I did?
The law actually looks at it from a slightly different angle when outright fraud is involved. The first-to-file rule only applies to independent creation. The code contains a specific safety net for the scenario you described under Section 68.
What's that called?
The remedies of the true and actual inventor. If you can prove to a court that you were deprived of the patent without your consent or through fraud, the court has the power to order the IPO to cancel the fraudulent patent and substitute you as the rightful patentee. You can even be awarded actual damages.
Well, that's a relief.
Right. The system demands speed, but it does not reward actual theft.
Good to know my teleporter blueprints are somewhat safe from literal burglary. But let's look at a much more common, everyday tension regarding who owns an idea. The code covers inventions created pursuant to a commission, and specifically inventions made by employees. Section 30. If you are sitting in your office right now using a company laptop to design something on your lunch break, you need to listen to this next part very carefully.
It is perhaps the single largest source of intellectual property litigation in the corporate world.
I believe it.
The default rule for a standard commission is straightforward. If you hire an engineering firm and pay them to design a specific machine for your factory, you own the patent, unless you signed a contract saying otherwise. You bought the creative labor.
Makes total sense.
But the employer-employee relationship is where the boundaries get incredibly murky.
Because an employee isn't necessarily hired to invent one specific thing, they are hired to do a job. So if an employee invents something while they are employed, who gets the multi-million-dollar patent?
The law resolves this by looking strictly at the employee's designated duties. If the employee invents something that is not part of their regular duties, the employee owns the patent. And this is the part that surprises many corporate managers. The employee owns it even if they use the employer's time, facilities, and materials to create the invention.
Wait. Let me test that. Let's say I'm hired as a mid-level marketing executive. My job is to design ad campaigns. But I noticed the coffee machine in the break room is incredibly inefficient. So on my lunch break, using the company's high-end 3D printer and company plastic, I prototype a revolutionary new coffee brewing valve that cuts brewing time in half. It meets all the criteria for a patent. Does the company own my valve because I use their printer on company property?
Under the default rules of the code, no. You own the patent.
Really?
Really. Inventing coffee valves is not part of your regular duties as a marketing executive. Now, the company might discipline you for wasting company resources or using the 3D printer for unauthorized projects, sure, but they cannot claim ownership of the intellectual property.
Wow. But the flip side must be equally rigid, right?
Oh, it is. If your job description specifically involves research, development, or improving processes, say, if you are hired as a mechanical engineer to improve workplace efficiency, then the employer owns the patent.
Even if I invent it on the weekend.
Even if you have the breakthrough idea while you're at home in the shower on a Sunday, the employer owns it. Because inventing that specific type of solution is exactly what they are paying you a salary to do.
So your job title is essentially the boundary line of your intellectual property. That is fascinating. But let's pivot slightly. What if my new coffee valve is definitely new, and it's definitely useful, and it can be mass-produced? But if I'm being honest, it's not exactly a massive inventive leap that would shock a person skilled in the art. It's just a really clever incremental tweak. Does the law just say, too bad, it's obvious, no protection for you?
That would be a massive failure of economic policy. Because the vast majority of commerce is not driven by world-changing paradigms like the microchip or teleportation. Commerce is driven by everyday tweaks, slight efficiencies, and aesthetic upgrades.
Right, the small stuff.
The drafters of the code understood this, which is why they created what you might consider the patent-light tiers of protection, utility models, and industrial designs.
Okay, let's unpack utility models first, Chapter 12. According to the text, a utility model only needs to be new and industrially applicable. It deliberately and entirely skips the rigorous inventive step requirement of a regular patent.
It dramatically lowers the threshold for protection. A utility model allows an inventor to protect an incremental innovation, a slightly better grip on a hammer, a more efficient way to fold a cardboard shipping box.
But there's a catch, I assume.
Yes, because the threshold for getting the protection is lower, the reward granted by the state is significantly smaller. A standard patent gives you a sweeping monopoly for 20 years. A utility model registration under Section 109 expires at the end of the 7th year after the filing date, with absolutely no possibility of renewal.
So it's a quick, short-term shield.
Designed to give you just enough time to recoup your development costs before the market absorbs the idea.
And then we have industrial designs, Chapter 13. The code defines this as any composition of lines or colors or any three-dimensional form that gives a special appearance to a product. So we are shifting away from how the thing works entirely and focusing purely on how it looks.
Because the aesthetic appeal is often what drives consumer choice. To be protected under Section 112, an industrial design must be new or original. But the critical limitation here is that the design cannot be dictated essentially by technical or functional considerations.
Give me an example of that.
If the shape of an object is the only possible way that object can function, for instance, the aerodynamic curve of a specific airplane wing, you cannot protect that curve as an industrial design. You would need a patent for that.
Because it's functional.
Right. But if the shape is purely aesthetic, the aggressive, stylized curve of a luxury car's hood or the unique pattern embossed on a leather bag, that is an industrial design.
And the timeline for that is different as well, right? Section 118 says the protection lasts for 5 years initially, but unlike the utility model, an industrial design can be renewed for 2 consecutive periods, meaning you can lock down the look of a product for up to 15 years.
Which is usually far longer than the aesthetic life cycle of a consumer product anyway. Trends change fast.
Very true. Let me put all 3 of these into a single real-world scenario just to see how they layer together. Let's say an automotive company pours billions into R&D and invents a completely new, highly complex type of electric engine battery that recharges itself using ambient heat. That passes the high threshold and gets a 20-year patent.
Correct. High threshold, maximum reward.
Then a junior engineer at the same company figures out a clever way to tweak the existing cup holder mechanism so it adjusts to different size cups using a simple tension spring. Not revolutionary, very obvious in hindsight, but highly useful. They file that as a 7-year utility model.
Incremental utility, shorter reward.
Right. Finally, the marketing and design team sculpts the exterior shell of the car with a sweeping, futuristic silhouette that has never been seen before. It doesn't make the car faster or more aerodynamic, it just looks incredibly cool and makes people want to buy it. They register that exact shape as an industrial design.
You've just perfectly mapped how major corporations layer different types of intellectual property protection onto a single product. They build a fortress of different overlapping rights.
Here's where it gets really interesting. I was reading through the procedural rules, and there is a brilliant strategic loophole, or rather a strategic release valve. Section 110. The code allows an applicant to convert a patent application into a utility model application, or vice versa, at any time before the final grant or refusal. It's like the law actively encourages you to hedge your bets.
It's an incredibly pragmatic piece of legislation. Let's look at the reality of filing a patent. You submit your application for a 20-year patent. 2 years go by as it works its way through the bureaucracy. Finally, the IPO examiner comes back and says, look, your invention is definitely new and it's industrially applicable, but I've reviewed the prior art and I just don't see an inventive step here. A person skilled in the art would find this obvious. I'm going to refuse the patent.
Which is devastating.
In many legal systems, that would be a catastrophic loss of time and money. You would lose your initial filing date and have to start entirely from scratch.
But with this conversion rule, you just pivot.
Exactly. Before the final refusal is stamped, you invoke the conversion rule. You tell the IPO, okay, I concede the inventive step. Convert this into a utility model application.
Oh, that's smart.
By doing so, you maintain your original early filing date, which protect you against competitors who might have filed during those 2 years. And instead of walking away with zero protection, you walk away with a 7-year monopoly. It acknowledges that the line between a genuine inventive step and a mere obvious tweak is incredibly subjective, and it doesn't punish the inventor for aiming high and missing.
I love the mechanics of that. Okay, so we've spent a lot of time on the physical product. We've protected the revolutionary engine, the clever cup holder, and the cool exterior shape. But when a consumer walks into a massive dealership or a crowded grocery store, they don't immediately see the engine or the tension spring. They are hit with a wall of choices.
They certainly are.
How do they know which product was made by the company they actually trust? If a competitor can't copy your battery, what stops them from just copying the logo on the box and tricking the buyer? That's an entirely different psychological vulnerability, which requires an entirely different legal shield. We have to leave the factory floor and look at the anchor of commerce, the brand.
This brings us to the law on trademarks, service marks, and trade names. If patents protect the functional physical reality of an invention, trademarks protect the commercial identity, the reputation, and the goodwill of the source. It is fundamentally about protecting the consumer from deception.
And the code makes it very clear how you establish this protection. Rights in a mark are acquired strictly through valid registration with the IPO under Section 122. You can't just draw a logo, put it on a sign outside your house, and magically claim you own it nationwide.
Right.
But the real meat of trademark law is found in the massive list of what you absolutely cannot register under Section 123.
The restrictions are designed to keep the playing field of commerce fair and sane. Some restrictions are obvious public policy. You cannot register a mark that consists of immoral, deceptive, or scandalous matter. You cannot register the flag or coat of arms of the Philippines or any foreign nation. But the commercial restrictions are where the real battles are fought. For instance, you cannot register a mark that is a generic term for the goods or services.
Which perfectly sets up my classic intellectual property thought experiment. If I open a fruit stand, why can't I trademark the word apple to protect my business?
Think about the acoustic resonance of that word in that specific context. If you were granted an exclusive legal monopoly on the word apple for selling apples, you would effectively destroy your competitor's ability to accurately describe their own products.
Because they need to call them apples.
Exactly. A generic term is the common, everyday name of the good itself. If the government let you own it, you wouldn't just be protecting a brand. You would be monopolizing the English language.
But a massive trillion-dollar tech company is famously allowed to trademark the word apple. How does the law justify that discrepancy?
Because context is the entire foundation of trademark law. In the context of selling computers, smartphones, and software, the word Apple is completely arbitrary. It has absolutely nothing to do with the function, the ingredients, or the nature of the machine.
That's true.
The tech company didn't take a word that competitors needed to describe their own electronics. No other computer manufacturer needs the word Apple to describe a microchip. The mark is arbitrary, therefore it is inherently distinctive, therefore it is registrable.
So you can't monopolize a description, but you can monopolize a non sequitur. Now, the code also prevents you from registering a mark that is confusingly similar to a mark that is already registered for identical or similar goods. If a famous shoe company sells a sneaker called the Velocity, and I try to register a shoe called the Velocity spelled with 2 E's, the IPO is going to block it.
They will, because trademark law doesn't just look at exact spelling. It looks at the overall visual and oral impression. It looks at acoustic resonance. If a consumer hears velocity on a radio ad, it rings at the exact same psychological frequency as the established brand.
The brain just jumps to the familiar brand.
Exactly. The brain's pattern recognition is tricked. The law recognizes that consumers don't always scrutinize spelling. They rely on general impressions. If the impression is confusingly similar, it's illegal.
But the limitation there is usually based on similar goods, right? If I register Velocity for a line of high-end running shoes, and someone else registers Velocity for a brand of industrial agricultural tractors, the IPO might actually allow both. Because nobody buys a massive farming tractor thinking it was manufactured by a running shoe company. The consumer isn't confused.
Generally, yes. The protection is usually limited to the specific class of goods you operate in, or goods that are naturally related. However, the code creates a massive, powerful exception for what it calls well-known marks under Section 123.1e and Section 147.2.
Ah, this is the super shield.
It truly is. If a mark is internationally and locally recognized by the competent authority as being universally well-known, think of brands like Coca-Cola or Rolex or Google. The boundaries of similar goods are completely shattered. The law extends their protection to goods or services that are entirely unrelated.
So even if nobody would realistically be confused, I still can't start a business selling Coca-Cola brand spark plugs for car engines.
Absolutely cannot, even though the goods are totally unrelated. The law states that using a well-known mark in that manner would indicate a false connection between your spark plugs and the beverage company. Furthermore, it would likely damage the interests of the trademark owner by diluting the immense exclusive goodwill they have built up over decades.
Because they spent a fortune building that name.
They have spent billions associating their name with a specific feeling and quality. The law won't let you free ride on that psychological investment, no matter what you are selling.
That is an incredible advantage for massive corporations. But the code doesn't just let you register a name, put it in a vault, and sit on it forever. There is a mechanism that requires active participation in the economy, the Declaration of Actual Use Rule, under Section 124.2.
Yes, a very important provision.
You file your application, but within 3 years from the filing date, you absolutely must file a sworn declaration accompanied by actual evidence that you are genuinely using the mark in commerce in the Philippines. Why does the law force the owner to prove they are actively selling things? Why can't I just claim a cool name for a future business?
Because an empty trademark is a chokehold on the economy. This requirement is specifically designed to combat a highly predatory practice known as trademark squatting.
Trademark squatting, how does that work?
Well, before these strict use requirements were enforced, a malicious actor could act as a commercial parasite. They would scour the globe, find successful emerging brands in Europe or the US that hadn't expanded to the Philippines yet, and quietly register all those brand names at the local IPO. Then they would just wait.
Holding the names hostage.
Precisely. Years later, when the legitimate foreign company finally attempted to enter the market, they would find their own name already registered. The squatter would then demand millions of pesos in essentially legal extortion to sell the trademark back to the rightful creator.
Wow, that's incredibly shady.
By forcing every single applicant to submit physical proof like actual sales invoices or photographs of the product on store shelves within 3 years, the law clears out the deadwood. It ensures that the trademark registry reflects real, breathing commerce, and it eviscerates the business model of the trademark squatter.
It's a strict use it or lose it policy. And it doesn't end after 3 years. Under Section 145, a trademark certificate only lasts for 10 years, and then you have to renew it and prove actual use all over again. It requires constant maintenance and constant commercial activity.
It does.
Before we leave the realm of brands, I want to touch on a fascinating subcategory mentioned in Section 167, collective marks. This seems to apply to groups rather than individual corporations.
Collective marks serve a very different commercial purpose. Instead of identifying a single, central manufacturer, a collective mark is used by a cooperative, an association, or a group of producers to designate a common origin or a common characteristic of their goods.
Can you give an example of how that functions in reality?
Sure. Imagine a massive cooperative of independent coffee farmers scattered across a specific, highly fertile mountain range. None of them are large enough to build a global brand on their own, but together, they register a collective mark for their specific region's coffee.
Okay, I see.
Anyone who is a member of their cooperative and who strictly meets their agreed-upon quality standards is legally allowed to print that mark on their packaging.
It's a seal of approval and origin.
Exactly. And to ensure the mark isn't abused, the law requires the cooperative to file a copy of the agreement governing the use of the mark with the IPO. The government needs to know exactly what the standards are and who has the authority to enforce them within the group. It allows fragmented producers to build unified, powerful, commercial goodwill.
That's a great tool for smaller players. So, trademarks protect the psychology of commerce. Patents protect the physical reality of invention. But what about art? What about the novels we read, the symphonies we listen to, the software we code, and the very deep dives we record?
Now we get to the really creative stuff.
Exactly. We leave the factory floor, we leave the marketing department, and we enter the studio. It is time to explore the law on copyright. And right away, the fundamental nature of how the protection is born feels completely different.
What's fascinating here is that the philosophical shift is jarring in the best possible way. With patents and trademarks, the protection is conditional. You have to beg the government for a monopoly. You have to file complex forms, pay substantial fees, undergo rigorous examinations, prove your inventive step, and wait years for a certificate.
It's a grind.
It is a formal, state-granted right, but copyright operates on completely different frequency.
According to Section 172 of the Code, literary and artistic works are protected by the sole fact of their creation.
The immediacy of that is profound. The moment a novelist writes a poem on a napkin in a coffee shop, the moment a photographer's shutter clicks, the moment a programmer hits save on a new block of code, an invisible, absolute shield of copyright instantly surrounds that work.
Just like that.
Just like that.
Yeah.
You do not have to register it with the government. You do not have to pay a fee. The right to control that work exists simply because a human mind manifested it into reality.
That feels almost magical compared to the grueling bureaucracy of the patent office. Now, once that magical shield is up, the law divides the power it grants into two very distinct baskets: economic rights and moral rights. Let's look at the economic rights first under Section 177.
Okay.
This is basically the right to control the commercial exploitation of the work. It's the exclusive right to reproduce the work, to translate it, to distribute it to the public, and to perform it. If a massive film studio wants to take your self-published sci-fi novel and turn it into a blockbuster movie, they have to negotiate with you and pay you for that economic right.
That is the financial survival mechanism for the artist. But the code recognizes that art is not just a commodity. It is an extension of the creator's identity. And that is why the law dedicates an entire section, Section 193, to moral rights. These rights are deeply personal and exist independently of the economic rights.
what does that independence mean in practice? Let's say I write a heartbreaking, tragic novel, and I sell the copyright to a major publishing house for $1 million. I've sold the economic rights. They own the right to print it and sell it. Do I still have any control?
You absolutely do, through your moral rights. Even after you sell the economic rights, you retain the moral right of attribution, the right to demand that your name be displayed prominently as the author of the work. The publisher can't just slap a different author's name on it to sell more copies.
Okay, that's good.
But more importantly, you retain the right to object to any distortion, mutilation, or modification of your work that would be prejudicial to your honor or reputation.
So if the publisher decides that tragedies don't sell well, and they hire an editor to rewrite the final chapter of my book so that everyone lives happily ever after,
You can legally stop them using your moral rights, even though they own the economic right to the book.
wait, really? Even if they bought it?
Even if they bought it, because changing your tragic artistic vision into a cheap, happy ending mutilates the work and prejudices your reputation as a serious author. The law protects the soul of the artist, not just the wallet. It prevents the commodification of the art from entirely erasing the intent of the creator.
I find that deeply reassuring, and the timeline for this protection is massive compared to patents. A patent lasts 20 years, but under Section 213, copyright lasts during the entire lifetime of the author, plus an additional 50 years after their death.
It ensures that an artist's immediate heirs, their children and grandchildren, can benefit from the creator's genius. It provides generational security.
But returning to our initial discussion of the grand bargain and the state policy of national development, the government can't just let artists own everything forever or lock away crucial information. So the law explicitly carves out categories of things that are entirely unprotected by copyright under Section 175. For instance, no protection extends to any idea, procedure, system, method, concept, or mere data.
The distinction between an idea and the expression of an idea is the absolute bedrock of copyright law. If you write a novel about a young wizard going to a magical boarding school, you own the specific sequence of words, the specific dialogue, and the specific names of your characters. That is the expression.
But I don't own the wizard school.
You do not own the idea of a magical boarding school. Anyone else in the world is free to write their own book about a wizard school as long as they don't copy your specific expression.
Ideas are the raw material of culture. If you could copyright an idea, the first person to write a romance novel could prevent anyone else from ever writing about love again.
Exactly. The law keeps ideas free, so culture can continually iterate. The code also explicitly excludes news of the day and miscellaneous facts from protection under Section 176. You cannot own the fact that a hurricane struck a certain city yesterday. And crucially, the law clearly states that no copyright shall subsist in any work of the government of the Philippines.
Meaning statutes, legal codes, judicial decisions, and speeches made in deliberative assemblies belong entirely to the public domain from the moment they are spoken.
The rationale there is democratic survival. A citizen cannot be expected to obey laws that are locked behind a corporate paywall. The public must have unfettered, unhindered access to the mechanisms that govern them. The government cannot claim a monopoly on its own dictates.
Speaking of human autonomy, there was one specific provision regarding artists that really stood out to me, Section 194, the rule against forced creative labor. The code states that an author cannot be compelled to perform his contract to create a work. Let's say a famous author signs a highly lucrative contract to write a sequel to their hit fantasy series. The publisher pays them in advance. But then the author just gets permanent writer's block, or maybe they decide they fundamentally hate the story and refuse to write another word.
It happens.
The publisher can sue them for financial damages, demand the advance back, and claim breach of contract, sure, but no court in the country can issue an injunction physically forcing the author to sit at a desk and write the book.
It is a profound legal recognition of the nature of the human mind. You can force a construction company to finish building a wall. You can force a supplier to deliver a ton of steel. But you cannot mandate inspiration.
You just can't.
It violates basic constitutional principles against involuntary servitude, but it also acknowledges that artistic creation requires the willing, active participation of the human spirit. A court order cannot produce a great novel.
That is so deeply human. And the law also looks out for the people who bring the art to life, not just the authors. The code covers the rights of performers, producers of sound recordings, and broadcasting organizations. There's a highly specific economic right under Section 206 regarding subsequent broadcasts. If a musical performance is broadcast subsequent to its first broadcast, the performer is entitled to an additional remuneration equivalent to at least 5% of their original compensation.
The concept of residuals is written directly into the National IP Code.
That's wild.
It recognizes the ongoing commercial value of a recorded performance. When a musician plays a song in a studio, they do the physical labor once. But if a radio station profits from playing that recording 1,000 times over the next decade, the law ensures the performer continually shares in the ongoing exploitation of their voice and talent.
Okay, we've talked about the absolute automatic rights of the creator, but I want to do a deep dive into the most fiercely debated, highly misunderstood section of copyright law, the ultimate gray area, the fair use doctrine found in Section 185.
Oh boy, here we go.
This is the battlefield for every single person making a YouTube video, streaming a video game, writing a blog, or recording a podcast. People online treat fair use like a magical incantation. I put no copyright intended in the video description, so you can't sue me. It's fair use. Let's shatter that myth right now. What actually makes something fair use under this law?
Well, a disclaimer in a video description carries absolutely zero legal weight.
Zero.
Zero. Fair use is not a right you declare. It is a highly nuanced affirmative defense that a judge evaluates on a strict case-by-case basis. The law states that the fair use of a copyrighted work for criticism, comment, news reporting, teaching, scholarship, or research is not an infringement. But to determine if your specific individual use is actually fair, a court will meticulously weigh 4 specific factors.
Let's test this framework. Let's walk through the 4 factors using modern digital scenarios. Factor 1, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. It seems like the moment you monetize a video, you lose this factor.
Commercialization definitely weighs against fair use, but it's not an automatic disqualifier. If you are a high school history teacher photocopying a poem for your 30 students to analyze in class, the nonprofit educational purpose weighs heavily toward fair use.
Because it's teaching.
Right. On the extreme opposite end, if a massive shoe corporation uses a hip-hop song as background music in a TV commercial without paying the artist, that purely commercial exploitation weighs heavily against fair use. But the real battleground in Factor 1 is transformative use.
Meaning, did you actually add something new or did you just copy it?
Precisely. If a YouTuber takes a 5-minute clip of a movie and talks over it, analyzing the cinematography, pointing out lighting techniques, and adding significant new educational commentary, they have transformed the original work into a critique. That weighs in favor of fair use.
But if they just upload the clip?
If they just upload the 5-minute clip with no commentary so people can watch the best fight scene for free, that is not transformative at all.
Factor 2, the nature of the copyrighted work. How does the type of art change the calculation?
The law grants a thicker shield of protection to highly creative fictional works, like a fantasy novel, a blockbuster movie, or a painting, than it does to purely factual works, like a biography or a historical documentary.
Why is that?
Well, if you quote a paragraph from a history textbook to write an essay, that's more likely to be fair use because society relies on the free flow of historical facts. But quoting an entire paragraph from a deeply personal, highly creative poem is much harder to justify.
Factor 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This is the how much did you steal test.
It evaluates both quantity and quality. If you quote 2 sentences out of a 500-page political memoir for a news report, the quantity is minuscule. That weighs toward fair use. But the quality aspect is dangerous. It asks, did you take the heart of the work?
Give me an example of taking the heart.
Imagine a gripping 2-hour mystery film where the entire plot hinges on a massive, shocking twist in the final 30 seconds. If a reviewer only shows 30 seconds of the film, a tiny quantity, but they choose the exact 30 seconds that reveals the killer and the twist, they have taken the heart of the work. They have completely destroyed the narrative value for a new viewer. That weighs heavily against fair use.
Which bleeds perfectly into the final factor. Factor 4, which always seems to be the heaviest anvil in the courtroom, the effect of the use upon the potential market for or value of the copyrighted work.
This is the brutal economic test. Does your use of the material serve as a viable market substitute for the original?
Let's look at the reaction video trend.
Perfect example.
If a content creator watches an entire 20-minute comedy special on a stream, laughing along but occasionally pausing to say, "That's funny," they might argue they are providing commentary. But a judge will look at Factor 4 and ask, If a viewer watches this reaction stream, do they ever need to pay for the original comedy special?
No, because they just consume the entire product for free through the streamer.
Exactly.
The streamer has created a market substitute. They have cannibalized the original creator's potential revenue. If your use harms the copyright owner's ability to sell their work, the court will almost certainly rule that it is not fair use. It is a delicate, holistic balancing test every single time, and it is never as simple as slapping a disclaimer in a description box.
Okay, we've mapped out the philosophical boundaries. We've defined the rigorous hurdles for patents, the psychological battlegrounds of trademarks, and the magical immediate shield of copyright. They all sound incredibly robust and sophisticated on paper. But as we know, the real world is not governed by polite disagreements over theory.
No, it is not.
The real world is full of industrial pirates, organized counterfeiters, and digital thieves who simply don't care about the boundaries. Rights on paper mean absolutely nothing without a sword to enforce them. We need to look at the teeth of the law. Let's dive into enforcement, infringement, and remedies.
A right without a remedy is merely a suggestion, and Republic Act No. 8293 does not make suggestions. It provides severe, devastating remedies for those who cross the line.
Let's examine the civil remedies first.
If someone infringes your registered trademark, say they start manufacturing cheap, counterfeit running shoes using your exact logo, you can sue them for damages under Section 156. The court can award you the reasonable profit you would have made if they hadn't stolen your sales. Or they can calculate the actual profit the infringer made from the theft. But the law goes further to punish bad faith.
How so?
The code states that if the court determines there was an actual intent to mislead the public or to defraud the complainant, the court has the discretion to double the damages. It's not just about making the victim whole. It's about punishing the malicious intent.
Double damages for malicious trademark infringement. And the sword gets even sharper for patents.
Dramatically sharper. Under the rules for patent infringement in Section 76, the court can award actual damages. But if the circumstances warrant it, if the infringement was blatant, willful, and deeply damaging to the inventor, the court can award a sum up to 3 times the amount of actual damages.
Triple damages.
Treble damages. The financial ruin for blatant, willful patent infringement can be absolute and catastrophic for a competing corporation.
So the financial penalties are massive, but what actually happens to the fake goods? Under Section 157 and 216, if a warehouse is raided and authorities find 50,000 counterfeit designer handbags, what is the mechanism for dealing with that? Do they just cut the fake logos off and donate the bags?
No. The courts have the power to order the complete seizure, impounding, and absolute destruction of the infringing goods without any compensation whatsoever to the infringer.
Wow.
They destroy the goods, they destroy the packaging, and they destroy the plates, molds, or matrices used to manufacture the fakes. And the law is particularly harsh and explicit regarding counterfeit trademarks. It specifically states that the simple removal of the fake trademark is not sufficient to permit the goods to be released back into the channels of commerce.
Why not? If you rip the fake logo off, it's just an unbranded bag. Why destroy the physical material?
Because the law treats counterfeit operations as a poison in the commercial ecosystem. If counterfeiters knew the worst-case scenario was just having to remove a logo and sell the goods at a slight discount as unbranded items, the financial risk of piracy would be incredibly low. By mandating the absolute physical destruction of the tainted goods, the law ensures a total, unrecoverable loss of capital for the counterfeiter.
Total economic destruction. And then we cross the line from civil lawsuits into the realm of the state. The criminal side. Section 217 outlines the criminal penalties for copyright infringement, and it treats large-scale commercial piracy not as petty theft, but as a serious economic crime.
The escalating penalties reflect that severity. For a first offense of copyright infringement, or even aiding or abetting it, the perpetrator is looking at imprisonment of 1 to 3 years, plus a fine of up to 150,000 pesos.
That's not a slap on the wrist.
No, it is federal prison time. A second offense bumps the mandatory prison time to 3 to 6 years, and the fine up to 500,000 pesos. And for a third and subsequent offenses, the perpetrator faces imprisonment of 6 to 9 years, and a fine of up to 1.5 million pesos.
So, what does this all mean for you, the listener? Let's bring this down to the street level. If I'm walking through a weekend flea market and I see a DVD of a movie that is currently in theaters, or I see a luxury watch being sold for $5 and I knowingly buy it, am I committing a crime? Am I going to face 3 years in prison for buying a fake watch?
The law makes a very crucial distinction here between the exploiter and the consumer. The criminal penalties target those who possess infringing copies for the purpose of selling, distributing for trade, or public exhibition.
Okay, so I'm safe.
If you buy a counterfeit watch to wear on your wrist, you are not the target of the criminal code. You might be supporting an illicit industry, but you are not committing the crime defined by the act. However, if you have a trunk full of 50 fake watches and you are standing on a street corner selling them, you are manufacturing, distributing, or possessing infringing items for the purpose of trade. At that moment, you are in the crosshairs of those escalating multi-year prison sentences. The law hunts the commercial exploiter, not the end user.
It aims the heavy artillery at the source of the supply. Now, before we wrap up, I want to touch on a really interesting concept that provides a safety net for people who didn't navigate the IPO bureaucracy: unfair competition, Section 168.
It's a vital safety net.
Let's say I start a small, incredibly successful local business selling handmade artisanal soaps. I pour my heart into the specific shape, the unique colors, and the highly distinctive packaging. But I never bother to hire a lawyer or register my trademark at the IPO. A massive factory sees my success, copies the exact shape, color, and packaging of my soap, and starts flooding the local supermarkets with inferior, cheap knockoffs. My loyal customers are totally tricked. Since I never filed the official paperwork, am I just completely out of luck? Can the big factory legally steal my identity?
No, they cannot. And this is where the law shows a deep understanding of natural commercial justice. You are absolutely protected under the doctrine of unfair competition. The law explicitly states that a person who has identified in the mind of the public their goods or business from those of others has a property right in the goodwill of that business, regardless of whether a registered mark is employed.
So the goodwill itself is the property.
Exactly. If someone employs deception or any other means contrary to good faith to pass off their inferior goods as yours, tricking the public, they are guilty of unfair competition. You can sue them for massive civil damages, get an injunction to stop their production, and they can even face criminal penalties.
That's amazing.
The law essentially says, even if you didn't file the bureaucratic paperwork, a competitor cannot legally lie and steal the reputation you built. It protects the mind of the public from deception as a fundamental principle, above and beyond protecting a paper registration.
That is a brilliant safeguard for small businesses. But the law also understands that not every infringement is a malicious, calculated theft. There's nuance for mistakes. Consider the innocent infringer rule under Section 159.
Right.
If a local newspaper publishes a paid advertisement submitted by a local business, and it turns out that ad contains a stolen, infringing trademark, the true trademark owner can't swoop in and sue the innocent newspaper for millions of pesos in treble damages.
It's a vital practical limitation on liability. You cannot reasonably expect a daily newspaper or a billboard company or a web hosting service to conduct a massive, deep dive legal clearance on every single classified ad or banner submitted to them by third parties.
That would destroy those industries.
It would. The law focuses the heavy financial damages on the actual malicious actor who placed the ad. The only remedy the trademark owner has against the innocent publisher or distributor is an injunction. Just a court order simply telling the newspaper to stop printing the ad in the future. It protects the innocent mediums of communication from being crushed by secondary liability.
We have journeyed through a massive landscape today. We started in the rigid, highly technical halls of the Bureau of Patents, evaluating the absolute threshold of the inventive step and the race of the first to file. We moved through the psychological battlegrounds of the Bureau of Trademarks, fighting over acoustic resonance, generic terms, and the incredible power of well-known marks. We stepped into the immediate, automatic, and deeply personal shield of copyright, exploring the delicate balance of fair use and the artist's moral autonomy. And finally, we confronted the severe, unforgiving reality of treble damages, the absolute destruction of counterfeit goods, and the multi-year prison sentences designed to crush commercial piracy.
It is, as we discussed at the very beginning, a vast, incredibly complex system trying to execute a continuous, precarious, high-wire act. Republic Act 8293 represents a society attempting to engineer human motivation.
Which is no small task.
Not at all. It grants exclusive, incredibly powerful monopolies to creators and inventors, allowing them the power to stop anyone else from making, selling, or using their ideas. Because history proves that is the only reliable way to motivate the massive capital investment required for human progress. But it tempers that power with strict time limits, mandatory use requirements, and fair use exceptions to ensure that eventually society reaps the ultimate benefit of that accumulated knowledge.
It meticulously builds the invisible fence around the idea, but it guarantees that one day, The fence comes down, and the property belongs to the public domain forever.
And if we connect this incredible architecture to the bigger picture of where society is heading, it raises an important, almost existential question about the very source text we review today.
What's the question?
Throughout the entirety of the Intellectual Property Code, there is a massive, unspoken assumption about the fundamental nature of creation. Section 219 explicitly states that the natural person whose name is indicated on a work is presumed to be the author. Section 26 requires an inventive step that is not obvious to a person skilled in the art. It protects the moral rights and the honor of the creator.
Right. The assumption is always a person, a human mind, experiencing human inspiration, solving problems.
Exactly. The entire grand bargain is predicated on incentivizing a human being. But consider the reality we are accelerating toward right now. We are entering an era where artificial intelligence can autonomously generate thousands of lines of functional software code, write symphonies that mimic the greatest composers, output photorealistic digital art, and even design new, highly complex chemical compounds for pharmaceuticals in a matter of seconds.
It's happening already.
It is. So how will an intellectual property code, a law, fundamentally written to reward human effort, protect human genius, and benefit the natural person, adapt to creations that simply have no human author?
Wow. If an AI feeds on a database and invents a revolutionary new technical solution for a battery, who filed first? Does an algorithm have an inventive step, or is it just processing data? And how can a machine possibly own a moral right to its reputation?
Those are the fault lines where this 20th century legal architecture will either adapt or break entirely.
That is the new frontier. We start this deep dive by talking about how intellectual property is like trying to draw a definitive boundary line in muddy waters, attempting to put a padlock on the invisible architecture of the human mind. It seems the waters are only going to get muddier as the very definition of what constitutes a mind begins to change. Something for you to deeply ponder the next time you hold a patented piece of tech, look at a trademark logo, or read a copyrighted book. Thank you for exploring the vault of human ingenuity with us, and we'll see you on the next deep dive.
Welcome to the debate. Imagine this. You unlawfully copy a book.
Or like a piece of commercial software.
Right, commercial software. And you get caught. The court hits you with this massive fine. But let's say you're completely broke. I mean, you simply cannot afford to pay that penalty.
Which happens a lot.
And in most legal systems around the world, that might lead to, a civil bankruptcy proceeding.
Yeah, or asset seizure, exactly.
But under the specific legal framework we're unpacking today, because you're too poor to pay that fine, the state will legally mandate that you sit in a prison cell.
Wow.
Yeah, for up to 9 years. Just to essentially work off that debt. I mean, it sounds like the plot of a dystopian novel. But it is actually a very real functional piece of legislation.
It is, and it really forces us to confront how we value the creations of the human mind. Because when we talk about physical property like a house or a piece of land, the boundaries are undeniable.
Right, you have a fence.
Exactly, you have a fence, you have a locked door. If someone trespasses on your land, both of you physically know it's happening. The owner's right to exclude people is absolute. It's visible. But intellectual property is entirely different. The walls are invisible. We have to construct those walls entirely out of words and legal statutes.
We do. And today, we are examining one of the most fascinating architectural blueprints for these invisible walls, Republic Act number 8293, the Intellectual Property Code of the Philippines.
The big one.
The big one. This is the comprehensive legal framework that governs patents, trademarks, and copyright in the jurisdiction. It sets the precise rules for how intellectual creations are protected and, critically, how violations are punished.
Right. It doesn't just sketch out these broad principles. It defines the exact mechanics of enforcement and, well, the sweeping powers of the state over intellectual creations.
Which brings us to the central disagreement we are exploring today. We are looking at the fundamental philosophical core of this text. The question is, does the Philippine IP Code fundamentally operate as an uncompromising fortress of absolute rights for creators? Is it heavily weighted toward draconian, uncompromising punishment for anyone who dares to infringe?
And this is where I've come in. Is it primarily a pragmatic, utilitarian compromise? Do the extensive limitations, the exceptions, and the state overrides prove that public utility ultimately supersedes the creator's exclusive monopoly?
And I will be arguing that this code is, without a doubt, a strict protectionist framework, defined by its severe punitive mechanisms.
While I'm going to argue that the code's myriad carve-outs and exceptions prove it is an instrument of public utility rather than an absolute property right.
All right, let me lay out exactly why the strict protectionist view is the only way to accurately read the reality of this statute. Republic Act 8293 is designed from its foundational architecture down to its sharpest teeth to provide ironclad exclusive monopolies to creators.
Ironclad is a strong word.
But it's true. I mean, you don't have to look at abstract policy declarations to see this. You just have to look at the extraordinary severity of its enforcement mechanisms. In civil remedies, the law doesn't just aim to make the creator whole.
Or compensate them for a lost sale.
Exactly. It actually aims to decimate the infringer. Under the provisions for patent infringement, courts are explicitly authorized to award triple the actual damages.
Triple! Triple!
And if we look at trademark infringement, the court can award double damages where there's an intent to mislead the public. We have to understand that this is purely punitive. It goes way beyond compensation.
Well, sure, it's a deterrent.
But then we reach the criminal penalties for copyright infringement, which structurally escalate to just an astonishing degree. For a third offense, a violator is looking at 6 to 9 years of imprisonment and fines up to 1.5 million pesos.
Those are indeed the statutory maximums, and yes, they are severe. But maximums are meant for the worst actors.
But it goes so much further than maximums. As I mentioned at the start of the show, the code explicitly mandates what is known as subsidiary imprisonment in cases of insolvency.
Right, the working off the debt part?
Exactly. Subsidiary imprisonment basically means if you infringe a copyright and you are too financially destitute to pay the fine imposed by the court, the state keeps you in a cage. You serve time in lieu of the cash. I see why you think the law is pragmatic, but let me give you a different perspective. A legal system willing to imprison a person for nearly a decade and hold them in jail for insolvency simply for copying a piece of work is a system fundamentally engineered to defend private intellectual property at all costs.
That is a dark way to look at it.
It elevates those invisible walls of the mind to the exact same untouchable status as a physical bank vault.
Okay, I come at it from a completely different way. You cannot judge the fundamental philosophy of a comprehensive legal code merely by staring at its maximum penalties, or what it does to its most egregious repeat offenders.
That's where the teeth are.
Sure, but to understand what a law truly values, you have to look at who the law deliberately exempts. The so-called exclusive right in this IP code is actually an illusion. It is heavily permeated by vast limitations that prioritize the public commons and market realities.
An illusion? That's quite a claim.
It is. There are entire sections of this law that explicitly strip the owner of the right to prevent private, non-commercial use, experimental use, and fair use. I mean, the code even goes out of its way to specifically protect the recompilation of computer programs for interoperability.
Fair use is pretty standard, though.
Yes, but the state is essentially saying to the creator, your property right ends the exact moment it stifles innovation or private research.
But those are highly specific scenarios. They don't negate the fortress.
They do, though, and they point to a broader philosophy of sovereign override. The government grants itself the sweeping power to exploit an invention completely without the owner's agreement.
For national security, usually.
For national security, yes, but also for health and nutrition. Or even simply if the patent isn't being worked commercially to meet domestic demand. If the government can legally bypass your so-called exclusive right just because the market demands more supply, or a hospital needs a drug, that is not an absolute property right.
That is a conditional lease granted by the state, purely for societal benefit. You don't own the house, you're just renting it from the public good.
Okay, if we're going to talk about the public good, let's look at what actually happens to the unauthorized goods themselves under this framework. Because the physical remedies in the code reveal an ideology of absolute intolerance for infringement.
Intolerance in what way? It's not just about stopping the behavior, it's about eradication. Let's look at the provisions regarding counterfeit goods. In many legal regimes, or just based on standard economic utility, if you unlawfully place a counterfeit trademark on, say, a generic t-shirt, the remedy might be to simply remove the illegal label.
Right. Remove the fake tag and let the plain shirt be sold to recoup some economic value.
Exactly. The fabric still has utility, right?
Right, that would be the economically efficient way to handle it.
But not under this code. The law explicitly states that the simple removal of the trademark affixed shall not be sufficient. The goods must be destroyed or disposed of outside commerce without any compensation whatsoever. And we see this mirrored in copyright as well. The code demands the delivery under oath for destruction of all infringing copies, as well as the plates, the molds, and the implements used to make them.
The machinery itself.
The machinery. Think about that mechanism for a second. The code treats infringement like a highly infectious contagion. You don't just cure the patient, you burn the infected clothing, you destroy the very plates and the molds.
Which is intense, I admit.
This mandatory destruction shows a total intolerance for infringement that deliberately overrides economic efficiency. It would be far more utilitarian to repurpose those raw materials. But the code chooses strict protectionism and the literal, ritual destruction of the infringing items to completely sanitize the market.
I'm sorry, but I just don't buy that. Let me tell you why. You're painting the code as this blunt, uncompromising instrument of destruction. Like this machine that just crushes anything that crosses the line.
Because it does. The plates are destroyed.
That you're completely ignoring the highly nuanced treatment of intent woven throughout the text. If the law were truly about sanitizing the market at all costs, like some sort of contagion protocol, it wouldn't care at all about the state of mind of the actors involved.
Strict liability regimes usually don't.
Exactly, but this code does care. Deeply. It creates explicit force fields around what it calls innocent infringers. Let's ground this in a real-world scenario. Imagine a small mom-and-pop printing press in Manila, or a local newspaper publisher.
Okay.
A client pays them to run an advertisement. That ad happens to contain an infringing, stolen trademark. The printer had absolutely no idea it was stolen. They were just doing their job.
They still printed the infringing material, though. I mean, they participated in the physical act of infringement.
They did, but under your contagion theory, the publisher should be held strictly liable. Their printing presses should be seized and melted down, right?
Well, if we follow the letter of the destruction clause.
But that's not what happens. The code explicitly limits the remedy against these innocent commercial actors purely to an injunction against future printing. It completely shields them from the devastating financial damages we talked about earlier.
It limits the remedy, yes. But I have to point out, it still grants the injunction. The state still steps in and halts the activity.
Halting the activity is just stopping the bleeding, but shielding them from financial ruin. That is the key philosophical point. It proves the law is a highly sensitive mechanism that refuses to punish good faith commercial actors.
I see what you're saying, but...
It fundamentally values economic continuity and the survival of innocent businesses over the IP owner's absolute vengeance. If this were truly a strict protectionist fortress, ignorance wouldn't be an excuse. The fact that the innocent publisher is spared shows the utilitarian heart of the code. It cares about intent because it cares about a functioning society.
I'm not convinced by that line of reasoning, mostly because you are treating the innocent infringer exemption as the philosophical core of the text, rather than recognizing it for what it is, which is just a pragmatic edge case.
I wouldn't call it an edge case.
To see the true philosophical core, we have to look at how the state treats a party who actually knows they are infringing. And here, the law doesn't just offer civil remedies. It crosses a massive legal Rubicon into outright criminalization.
You're talking about the repeat offenders.
Yes. Let's look at what happens when you merely repeat a patent infringement. Let's say a court issues a final judgment that you have infringed a patent. You lost the civil suit. But then you do it again.
Which is a bold move.
Extremely bold. And you don't just face another civil lawsuit for damages. The code criminalizes that repetition. You face a criminal conviction, imprisonment for up to 3 years, and hefty fines. The state is literally utilizing its monopoly on violence, the threat of the prison cell, to enforce a private patent on a commercial product.
Well, to be fair,
repeat defiance of a court order is generally frowned upon in any legal system.
Yes, but when the state takes a civil tort, which is essentially just a private business dispute over a process or a product, and elevates it to a criminal offense, it is elevating intellectual property to the exact same level as fundamental physical property. You go to jail for stealing a car. Under this IP code, you go to jail for stealing an idea.
That is a jump, though.
There is no clear definition of strict protectionism than the state saying, we will put you behind bars if you touch this abstract concept.
That's a compelling argument, I admit. But, have you considered the incredibly powerful timeline caveats that completely undermine the idea of an absolute monopoly?
Timeline caveats?
Yeah. You bring up the criminalization of someone who knows they're infringing. Let's look at the concept of good faith and how it actually strips the patent owner of their exclusivity entirely.
Okay, go on.
Examine the concept of prior user rights. Let's just walk through a timeline here. Suppose I independently invent a new manufacturing process, and I undertake serious financial preparations to use it in my factory.
So you invest money in it.
Right. I buy the machinery, I hire the staff, I do all of this in absolute good faith, not knowing you or your patent exist. A month later, you file a patent for the exact same process and you win the grant.
Under a strict property regime, the first to file wins. The patent is an absolute monopoly.
Exactly. Under your fortress model, you could march into my factory with your new patent and shut my entire operation down. But under the prior user right in this code, I have the statutory right to continue using that invention. Your so-called exclusive patent absolutely cannot stop me.
To be fair, though, that prior user rights is strictly limited. It can only be transferred with the enterprise itself. You couldn't just sell that right to a competitor.
It is limited to my business, yes, but the fact that it exists at all completely breaches the fortress walls. It means the monopoly is not absolute. Furthermore, look at how damages are handled in trademark suits.
Regarding notice?
Exactly. The code states that damages simply cannot be recovered unless the infringer had knowledge that their imitation was likely to cause confusion. The burden is put entirely on the IP owner to prove they gave notice, like displaying the registered mark symbol on the packaging.
The little R in the circle.
The little R. If the property right is entirely subservient to the timeline of market realities, if someone else was there first in good faith, or if you failed to put a warning label on your product, the state flat out refuses to punish the trespasser. That means the right isn't absolute at all. It is highly conditional on commercial context and the behavior of the owner.
Look, I understand the emphasis on conditional rights, and I agree those mechanisms exist. But we are debating the fundamental, overriding nature of the framework. You're relying heavily on the idea that the state prioritizes public utility over the individual right.
Because it does, and I will drive that point home by focusing on what I believe is the absolute most utilitarian mechanism in the entire code, compulsory licensing.
Ah, yes.
I like to think of this as eminent domain for ideas. This is where the protectionist illusion completely evaporates. Under the code, the Director of Legal Affairs has the statutory authority to grant a license to exploit a patented invention to a third party, completely without the patent owner's agreement.
Which is a massive power.
It's huge, and the circumstances for this are breathtakingly broad. It's not just for extreme national emergencies, though that is, of course, included. Imagine a life-saving pharmaceutical drug during a health crisis.
Right.
But a compulsory license can be granted simply because the patented invention is not being worked in the Philippines on a commercial scale without satisfactory reason.
Basically, if the patent owner is hoarding the technology.
Precisely. Think about the economic and philosophical truth this reveals. The state grants you a patent for one reason: to stimulate the domestic economy and promote progress.
Sure.
The moment your monopoly fails to stimulate the economy, or the moment you artificially restrict supply to the detriment of the public, the state steps in. They break your monopoly, and they forcibly share the technology with someone who will actually use it. Intellectual property here is not a sacred, untouchable right. It's a pragmatic tool. And when the tool isn't serving society, society simply takes it back.
That's an interesting point, though. I would frame it differently. You are portraying compulsory licensing as a sort of state-sponsored expropriation, this utilitarian free-for-all where the property right is just dissolved the moment the state deems it convenient.
Dissolved might be a strong word, but bypassed, certainly.
But that ignores the massive, strict procedural roadblocks the code places on compulsory licensing specifically to protect the creator's economic right.
The procedural roadblocks might be thick, but the state still overrides the owner's choice at the end of the day.
But the procedure matters immensely. The procedure defines the nature of the taking. Before any compulsory license can even be granted for the non-working of a patent, the petitioner must prove to the government that they made concrete efforts to obtain authorization from the patent owner.
On reasonable terms.
Exactly. On reasonable commercial terms and conditions, and that those efforts failed. The state doesn't just hand over the technology because someone asked nicely. It forces the market to attempt a fair, private negotiation first.
Right.
And even more crucially, the code guarantees the patent owner adequate remuneration based on the economic value of the license. The terms of the license must be fixed to ensure the patentee is paid.
But they are still being forced to accept a deal they didn't want to make.
True. But compulsory licensing is not an abandonment of the property right. It is a forced transaction. The creator's financial interests are still fiercely protected by the state. They aren't losing their property to the public comment. They're being mandated to lease it, and the state acts as the heavy-handed enforcer to ensure they get paid their royalties.
I see your point.
If we zoom out and look at the totality of what we've discussed today, the Philippine IP Code establishes a rigorous, heavily fortified structure around human creativity. We're talking about a legal regime that arms creators with the threat of triple damages in civil court, that mandates the physical destruction of infringing goods and the literal machinery used to make them.
The plates and molds, yeah.
And that is willing to leverage up to 9 years in state prison for copyright violations. Does the code contain exceptions? Yes. Does it contain compulsory licensing? Yes. But those exceptions are tightly regulated, procedurally burdened, and heavily compensated. The exceptions do not swallow the rule. The exclusivity of the right remains the beating heart of the text.
And I look at that exact same totality. I look at all those same mechanisms, and I see a masterclass in utilitarian balance. Yes, the penalties are severe, but a legal framework that explicitly permits the government to seize patent use for public health and national security is not absolute.
Even with the remuneration.
Even with it, a law that deliberately shields innocent publishers from financial ruin, that allows prior users to continue their factory operations without interference, despite a new patent, and that forces patent holders to actually work their inventions or face compulsory licensing, is a law deeply rooted in the public good.
It is a delicate balance.
To encourage innovation and reward creators, but the moment that monopoly threatens public welfare, market efficiency, or the flow of vital information, the state does not hesitate to pull the lever back.
It is a remarkable tension to analyze. I think there's incredible value in reading legal texts, not just for their loud prohibitions, but for their quiet exemptions.
I completely agree.
Because it is precisely the friction between the severe, terrifying penalties and the pragmatic, day-to-day carve-outs that illuminates the true values of the society that drafted them.
The boundaries of the law are often defined by where it specifically refuses to go. And honestly, there's still so much more to explore in this material. We haven't even touched on the unique quasi-judicial powers granted to the Intellectual Property Office itself under this code.
Oh, that's a whole other topic.
It is, like how the Director of Legal Affairs operates almost as a specialized court to settle these incredibly complex disputes before they ever reach a traditional judge.
That would be a fantastic avenue for a future discussion. For now, we will leave the final verdict to our listeners to weigh the evidence. But as you look at the landscape of intellectual property, you have to ask yourself, when the law builds invisible walls out of words, is it designing a fortress to keep the public out, or simply laying down the lanes for a more orderly public thoroughfare?